When there's no, what is also interesting is if you look at the entire statutory scheme, is there's no provisions for what to do if there are two different tactical recounts conducted by two different parties. The question that goes back to the original question that was asked by Justice Sills. When there are two different recounts, and some were to mix and match a partial manual count with a partial count by one of the components used originally, and you have two winners, the trial courts have absolutely no guidance as to how to deal with that, because the statutes don't account for that, because the legislature never meant to allow that in the first place. Because the only presumption set up is manual controls over electronic. But if you mix them, and you have a little bit of manual, a little bit of electronic, a little bit of, a memory card, and you just pull and mix and match to get to a point where you finally win, and both sides do that, how is the trial court ever going to determine who's the winner? And all you're going to do is create a full employment act for clever political consultants who will become absolute geniuses at gaming these things, so that we can even have in some cases three winners if we have three people very close to the top. That is an invitation to chaos. There's no reason to go there. The neutral third parties that have looked at this, the Secretary of State and the California's Office of Legislative Counsel, they both have reached the same conclusion with the appellants. They get it. They understand the chaos, and they have held, and the material has been filed with the court, that the DVPAT shall be counted for any full recount. The third question before the court is, does the Elections Code allow these kinds of tactical recounts where you can switch methods? In other words, what is the proper construction of 15627A? Respondents suggest that, and the trial court found, that the construction urged by the appellants would essentially gut 15627A and take away their ability to make a selection. Nothing is further from the case. We do not take that ability away at all with the construction that we're urging. Keep in mind that that 15627 is a very general statute. It covers every kind of counting and recounting system that's used in our state. We're a diverse state. We have large counties, we have small counties, we have large municipalities, we have small municipalities. They have an endless variety of ways in which they count. Some are little counties like Amador, maybe they count all just by hand. There are other counties where they may use an optical scanner where people vote by hand, but they run them through. This is a very general statute, 15627. It's only intended to do one thing, which is say if you want to do a recount, you have to say which method. That's all that statute is intended to do. Manual or by means of the voting system used originally. Now, if you select by means of the voting system used originally, do you always have to be counting paper? Not necessarily. For example, if this election had been conducted in Orange County 4 years earlier, there were no BVPATs in Orange County 4 years earlier. So the electronic votes were only counted by the MVP memory stick and by way of the paper manual tally sheet. And the absentee votes were only counted by optical scanners. So in that circumstance, if you requested one by means of the voting system used originally, you would have gone through and counted everything by machine. So we are far from saying you don't get a choice. In that circumstance, you could have requested manual and had everything done by hand, or you could have requested by machine and everything done by machine. What the statute just says is, whatever the system is, that's what you've got to live with if you don't want to go manual. And then they created a presumption, the legislature has, that if it's electronic and there's paper, they want that paper counted because they have concerns about its accuracy.